to talk about is we had talked about the open instruction with respect to the defendant's right to remain silent. Mr. Davis, you indicated last week that you do not want the court to read that this morning to the jury. Is that still your desire, or do you want the court to read that as part of the opening instructions?
No, Judge, we still ask that you not read that portion of it.
Okay. Let's go ahead and The preliminary instructions are going to announce as follows. Zachary Wester is charged with racketeering, official misconduct, perjury, fabricating evidence, possession of a controlled substance, possession of drug paraphernalia, and false imprisonment. That's based on the proposed jury instructions given to me by counsel. Is that an appropriate way to introduce the charges as pending against Mr. Wester? Specifically, the court doesn't mention the number of counts. But again, that was pulled directly from the proposed jury instructions. State, are you okay with that announcement?
Yes, sir.
Defense, anything you want to say with that announcement?
No, Your Honor.
Okay. Last thing that we need to address before I hear from the state and defense on any other matters they want addressed. It was indicated to me that when we went through jury selection last week, there were three third lay witnesses who were not discussed with the jury. There was Falk, Shaw, and Penn. It's my understanding that the state is going to get up and address the jury pool to make sure that they don't have any personal knowledge of those three individuals, and if they do, that won't impact their ability to be fair and impartial in the trial. State, is that still the anticipation?
Yes, sir.
Obviously, if we believe we need to follow up, Mr. Davis, I'll give you any follow-up that you may need. So those are three preliminary issues that I wanted to address before we bring the jury in this morning. Anything from the state's perspective we need to discuss before we get going?
No, Judge.
Mr. Davis, anything that you want to discuss?
No, Your Honor.
All right, let me just take one more peek. Okay. All right, if you want to give them a knock, Mr. Bailiff.
He just said he got about 4 in restrooms.
Okay. We got a last-minute restroom break from our jurors before we get started because I knew we may be sitting here for a couple hours. Let's just go through our process while they're doing their last-minute business before we bring them in. The first thing that we're going to do is I'm going to go through the Falk, Shaw, and Penn issue. After that issue is completed, I will swear in the 9. If you'll remember, we selected last week, but we did not swear in. We will swear them in. Mr. Clerk, if you'll be prepared to do that today. After we swear them in, I will go through my preliminary instructions. That will take me about 5 minutes to do that, maybe 10. After that, the state will give their opening, and then the defense will as well. I've got a podium set up here for you. That's typically where we've been using to give the opening. Obviously, you're addressing. There are 2 black X's on the floor. One X right now is covered by that podium. The other X is really right there in front of that clerk, where the clerk is. If you look on the floor, kind of in between the bench. A lot of times what counsel has done is they've rolled, after their opening, they've rolled that there and done direct and cross from the podium. That way you can see your witness and you can see the jury. So feel free, those are the 2 primary places. Another part of that is you'll notice microphones are set up close to that podium at both of those X's. That way we're catching what you're saying for our record today. So if you'll be cognizant of that, if you'd like to move it somewhere else, please let me know. And you've got liberty to do that. The one thing I do want to make sure is we've got a microphone near you. The microphone at the podium that's attached to the podium does not catch what we need it to catch. So we've got to have a microphone near you. And the bailiff will be glad to help you with that. Mr. Gary, how are we looking in there?
They all should be finished with their comfort break, Your Honor.
All right. Any other issues we need to address before we get started today? Another thing that's interesting is we have we've got a little bit more flexibility outside of the courtroom with respect to the mask. If anybody has a problem hearing the witness, please let me know, because I think we'll do what we need to do so that everybody can hear. Obviously, if you're having trouble hearing the witness, I would have concern that the jury is not hearing the witness either. So anytime that you have an issue hearing, please let me know. There's probably going to be times that I ask you to speak up as well, just to make sure we've got adequate volume. All right. Y'all ready to bring them in? State?
Yes, sir.
Defense? You ready? All right, let's go ahead and bring them in.
It's all rise. Good morning. We are ready to begin. Please follow me into the courtroom. Make sure your masks are on, and your phones and personal items.
Thank you. Please come to rest. Good morning, jurors. I appreciate you being here today. As you can see, this is our courtroom, and you are in what we have created is a jury box for you, which is normally where our audience sits in the courtroom. The state is sitting in where you would normally sit, and the defense's table is moved. So we've adjusted our courtroom in an effort to make sure that you're appropriately socially distanced. And we appreciate you staying in or around that X that you've got in your seat. It's kind of your space. That way we're socially distanced from each other, and hopefully everybody feels comfortable while we're in the courtroom to the extent possible. If you'll make sure that we wear masks, that would be wonderful. We'll take breaks, as we discussed last week, and make sure that you have an opportunity to take those masks off routinely during the day. We also we should have had some waters and snacks available for you, and I told you that if you wanted to bring something, that's fine as well. Feel free to bring a bottle of water if you need to into the courtroom, especially if you've like me and you may have mowed the grass over the weekend and have sinuses and feel like you're coughing and sneezing. Sometimes a bottle of water will help you with that. So feel free to bring water in here with those bottles as you may need to do so. This is State of Florida versus Zachary Wester. A couple things we need to address before we get too far down the road with you. It came to my attention after you all had left on Wednesday that there were a couple of potential witnesses that we want to make sure that we understand your relationship with. In the case, if you'll remember last Wednesday, we probably went through 40 to 50 witnesses and listed them and asked you, do you know any of these people? And if you do, would that relationship cause you where you could not be fair and impartial in this case? And we just, we talked over the latter portion of last week, me and the attorneys, and there were a couple that we think we need to address with you in case there are witnesses in this case. That being said, I'm going to go ahead and ask the state if you'll come up to the podium and ask these jurors about these three potential witnesses. Go ahead, counsel. So this is an extension of what we did last Wednesday.
Morning. Just like a jury selection, I'm going to read these names off. There's only 3 of them, so it won't take as long. But I'm going to read them one at a time. If you believe you may know this person, you recognize their name, just put your hand up. Laura Penn, Kenneth Shaw, and Christy Falk.
Okay, thank you, counsel. Mr. Davis, anything else?
No, sir, doesn't believe anybody raised their hand.
All right. Again, we just wanted to make sure that there was no relationship between any juror and those 3 potential witnesses, and the court's comforted by addressing that issue this morning, that there's no inappropriate relationship and it would not cause any of these jurors not to be able to participate as a juror in our case today. At this time, what I'm going to do is go ahead and begin with our preliminary instructions after swearing the jury in. Again, it's been a few days since we've seen each other, jury. At this time, I'm going to go ahead and have the state reintroduce themselves. Sir, if you'll stand up, please.
Tom Williams, representing the state of Florida in this case.
Thank you, Mr. Williams. And Mr. Davis, if you'll announce yourself and your client, please.
Good morning, everyone. My name is Ryan Davis, and I'm here representing Mr. Zachary Wester.
Mr. Wester, if you'll stand up too. Thank you, sir. Appreciate it, Mr. Wester. You'll notice we've got various screens located. I've got a screen in front of me. If there's any issue hearing or seeing, please let me know. In fact, the best way to do that is if you can't hear something, if you'll raise your hand, I'm constantly looking out the audience. That will tell me that you're having an issue hearing, and we'll do something different to make sure that you can hear what's being said today. At this time, is there any reason from the state or the defense that we should not go ahead and swear in our 9 jurors?
No, Judge.
No, Your Honor.
All right, if all 9 will please stand and raise your right hand. Mr. Clerk, if you'll go ahead and swear in our jury in this case.
You solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence, so help you God.
Thank you. Please be seated. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Zachary Wester. This is a criminal case. Zachary Wester is charged with racketeering, official misconduct, perjury, fabricating evidence, possession of a controlled substance, possession of drug paraphernalia, and false imprisonment. The definitions of these crimes will be explained to you later in this proceeding. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you in this case. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Zachary Wester in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of trial, the attorneys will have an opportunity, if they wish, to make what we call an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will instruct you on the law applicable in this case. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the instructions, you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law that I will give you. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law that I will give you. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up information about the case. If you become aware of any violation of these rules, please notify a bailiff and I will address it. During the course of the trial, the court will take recesses, and you will be permitted to go separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell him or her you are on the jury trying the case and ask them to stop. If they persist, leave him or her once immediately, report the matter to the bailiff, and I will deal with it. All cell phones, computers, tablets, or other devices must be turned off while you are in the courtroom. Turned off means that the phone or device is actually off and not in silent or vibrating mode. You may use the devices during your recesses, but even then you may not use your cell phone or device to find out any information about the case or communicate with anyone about the case or the people or places involved in the case. Please do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, we will double check to make sure that our cell phones and devices are turned off. At the end of the case, while you are deliberating, you will not be able to communicate with anyone outside the jury room. We will talk about that as we get to the end of this trial. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved. This applies whether you are here at the courthouse, at home, at lunch, or anywhere else. You must not visit places mentioned in the trial or use the internet to look up maps or pictures to see any place discussed during the trial. Jurors must not have discussions with friends or family members about the case or the people and places involved, so do not even let the closest family members make comments to you or ask you questions about this trial. In this age of electronic communication, I want to stress again that just as you must not talk about this face-to-face, you must not talk about this case by using any electronic device. You cannot use phones, computers, or any device to communicate about this case. Do not send or accept messages related to this case or your jury service. Do not discuss this case or ask for advice by any means, including posting information on a website, chat room, or blog. Why do we have these rules? And we discussed this at length last Wednesday. These rules are imposed because you as jurors must decide this case without distraction and only on the evidence presented in this courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system. Our system assures every party the right to ask questions about and to challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by any juror would unfairly and improperly prevent the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court, face sanctions, serving jail time, paying a fine, or both. The attorneys in this case are trained in the rules of evidence and trial procedure. It is their duty to make all objections that they feel are...
That he knew how to do it as a deputy here. Now, he worked, as I said, for 4 weeks under someone's direct supervision, someone called a field training officer. You may hear it abbreviated throughout the case as an FTO, but that's what that is, a field training officer. He worked under that person's direct supervision for that time, doing the kinds of things like you would expect. You're gonna hear that. That field training officer is gonna testify here shortly, and he's gonna tell you what all that entailed. But it's more or less what you would expect, how to handle yourself, dealing with the public, how radio and dispatch system worked at this agency, how to handle and collect evidence, where to place things, how to document things properly, all those kinds of things. You will hear that the defendant proved himself to be very competent. In fact, the FTO, field training officer, is going to tell you that Zach Wester was one of the best trainees he ever had. He never had to tell him anything twice. He proved himself to be more than competent and knew how to follow the policies properly of this agency. You'll hear that the sheriff's office has different divisions. They have a narcotics division, they have a command staff, an internal affairs division, and then they have what's called a patrol division. And some of you may know, but there will be testimony, and it'll tell you just in case, that a patrol deputy is assigned to a particular area of the county, and they literally patrol that area. They have those patrol vehicles that are marked, they're in uniform, and this is actually where most citizens in the public come into contact with a member of law enforcement. It's actually a patrol deputy. It could be anything from someone who makes a complaint and that person's the first responder. It could be a traffic accident. It could be you getting pulled over for a ticket. And that is how the defendant came into contact with each one of the victims in this case. Each one of them was pulled over by him during a traffic stop. One of the areas that you're going to hear a little bit about for that training is the use of body cameras. You'll also hear them referred to as body-worn cameras, but they're body cameras. And you'll hear testimony explaining what a body camera is, and it is what it sounds like, but it's basically a black camera that's affixed to the front of a deputy's uniform. And the idea is that it would allow whoever can watch a video downloaded from that camera to have the observation that the patrol deputy would have. There are many benefits to it, including the use of this very court system, and you will get to see many body cameras in this case. But the idea is that we can all see, as best we can, what really happened. Now, in February of 2018, a lady named Teresa Odom was driving home from seeing a family member at the hospital. She was pulled over by the defendant, Mr. Wester. Now, her truck at that time was pretty old and pretty beat up. You're going to get to see it on the video, and no one's ever going to contest that. Mrs. Odom will tell you that. And her brake lights were not working properly. So Deputy Wester pulled her over. And his camera turns on. He turns it on at the very beginning of that stop and makes contact with her, and you'll see that. Apparently there had been some weather the day before, a couple days before, and perhaps that had an effect on it. But either way, there were some issues with her brake lights. The defendant lets her know the reason for the stop. She says, "Yeah, I understand." And after that, the defendant asks her if he can search her car. She's going to tell you that she agreed. She didn't have anything to hide, so she said yes and got out of the car voluntarily. When she gets out of her car, there was already a second backup deputy behind her. So she got out, she walked back where that backup deputy was, and you'll see it, it's about a full car length's space, and she stayed back there with the only other deputy at that time who was on scene. And one thing that you'll notice when you watch Mrs. Odom's video at that point is so common to what these other victims will tell you in this case, and what the other videos will show you, is that while the defendant was searching her car, in other words, once she's out, he has complete access and complete control of that car. Only him. These backup deputies are out of view. They're literally back up. They're standby. And, of course, the occupants of the car are not still in there. They're removed. It's just him. And all we have is what his body camera video shows and what he would later put in his arrest reports when he arrested these people. Now, the defendant began the search of Ms. Odom's car at the driver's side door. And as he's getting ready to search, he's putting his search gloves on, these tactical black style search gloves, similar to ones that you guys have probably seen, but you will see them in the video, and they are evidence in this case. Now, as he's putting these gloves on, you can see on the video that he has his left hand clasped shut like this as he's putting them on. And you will see right here in this corner, you'll see a small white object in his hand, right by where his hands are clasped, as he's putting the gloves on. You'll see his hand drop down out of view towards the floorboard of Miss Odom's car. Now, you can't see where his hand is. As I said, it drops out of view at that point. And as I said earlier, the body cameras, the idea is that we can see as best we can what a deputy sees. And it's going to be up to you, the trier of fact in this case, to decide when things are out of view if that's intentional or if that's just the way it works, if it's accidental. But the video from Mrs. Odom's search will show basically her seat cushion. You'll see a purse in front of it, and then you'll see a seat cushion, a real close-up view of it. You'll see the defendant's left hand partially come back into view and reach over into her purse, which was in that seat. And her purse had the things in it that purses have, you know, her personal effects, her hair brushes, things like that. What you will see him take out of that purse, you can't see where he takes it out because that's partially out of view. But what you'll see him then take out and bring into view of the body camera is a small white baggie of methamphetamine. He takes that baggie and bends down and takes a metal spoon off of the floorboard of Mrs. Odom's car, and he sets the baggie of methamphetamine in the spoon. You'll hear that one of the ways that methamphetamine can be used is that it can be placed in a spoon. In other words, poured out of the baggie, placed in a spoon, and then some kind of a heat source, like a lighter, is underneath it, and then it is melted and placed into a syringe to be injected into somebody's arm or body. That's one of the ways that it can be used. Well, Miss Odom is going to tell you that that was an old spoon, and you hear her say it on the video. Says that was an old spoon that she had been eating yogurt with and had left on the floor of her car. Now, that's not going to be the cleanest or the most organized thing, but that's just what Mrs. Odom is going to tell you. And you're going to get to see her car and see for yourself that it's, by some people's standards, not the most clean car. Let's just say it. That's what she's going to tell you, and that's what it's going to show. But you're also going to get to see, members of the jury, that spoon. It is an item of evidence. You're going to get to see it. And on the bottom of that spoon, there will not be any burn marks, any char marks, any discoloration. When the defendant took that baggie of meth in that spoon, he walked it around from her car and walked it in front of her. And she immediately and adamantly denied it. She says, "No, sir. That is a yogurt spoon, sir. And I don't know what that is." She's adamant in her denial. She even asked Mr. Wester if they can test that spoon for yogurt. She asked him if she can test that baggie for prints. Now, that's not what they do roadside. That's not what a patrol deputy does roadside, but she's asking that, and you'll see it. Despite her pleading, despite her denying that it was hers, the defendant he does arrest Mrs. Odom, and he takes her to jail. The defendant makes a choice when writing a report for this and does not include that she requested that the item be tested for prints or that she even asked that it be tested for yogurt. Now, on the way to jail, the defendant drives her there, and you're going to get to hear from that video the defendant say something right from his own mouth on that video. He says, I tell people this a lot, says this Miss Odom. You got to be careful who you have around. And unfortunately, a lot of people you think you can trust, you can't. And just like that, Miss Odom and the other victims that you'll hear from in this case will tell you that they were powerless and they were taken to jail for crimes they didn't commit, for allegedly having methamphetamine in their car that they say wasn't there until after the defendant was in their car and searched their car. In several of these stops, the defendant has what we're calling a partial body camera video. So it's different than Mrs. Odom's video that I just told you about, where it shows a stop from the beginning, the first encounter with that person, to the very end of that stop. Most of the videos in this case are actually partial videos. And by that, let me explain what you will see when I'm referring to them as partial videos. All we have from the defendant, from his body camera, are short clips. Some end before a search actually happens. You'll see some where he stops his car, he makes contact with the victim who's driving the car, explains the reason for the stop. He goes back to his patrol car, and then the video abruptly ends. However, that's not when his contact with the victim ends. You're going to hear from those people what happened after that video was off, after that camera was off. That he searched their car, and he allegedly found methamphetamine in it, which they denied was theirs. But it's off camera. There's no video of it. And all we have is what the defendant puts in his report to document it. Other times, it's the opposite. We have portions which begin immediately after a search has allegedly discovered or returned methamphetamine or a syringe or a straw or some item of paraphernalia with the methamphetamine. But we don't have, for no apparent reason, we have nothing before that. There's no video evidence before that to show him finding this methamphetamine or the paraphernalia. Now, we all know that there's mistakes in technology. That's the world we live in. Anybody that's got a computer or a phone, we all know it. And the Jackson County Sheriff's Office, their policy on body cameras actually contemplates this and addresses it, that there can be technological problems. There can be reasons why a body camera malfunctions, sure. And you're gonna get to see that in the policy. The policy is that those instances are supposed to be documented whenever they're discovered. A deputy is supposed to place in a report whether or not a camera was working entirely or not working, or only captured part of an event. And if known, there's supposed to be some kind of an explanation why. You will see these reports that the defendant authored in these cases for these victims, and not once does he report in there and explain why there are these partial videos. Now, fortunately, some of these stops, like Mrs. Odom's, had other backup deputies. And as I told you a moment ago, and as you're going to hear, the policy for patrol deputies was that they're supposed to press that button on that body camera, turn it on as soon as they're on scene, and they don't turn it off until they're done, even if they're backup. Well, fortunately, some of those deputies in the case actually were following policy, and that we have those cameras, and that's why we have extra videos that otherwise we would not have. And between the partial videos, a couple of complete videos, and then other backup deputies' videos, a pattern will develop, and you will get to see that pattern. It's up to you to decide what to do with it, and more on that later. But one thing that you will see often, and you will hear testimony about often, is that the defendant returns to his patrol car during the search. In other words, what I mean by that is the defendant begins a search of someone's car. Front seat, side seat, whatever, you're going to see that. But he searches an area for a little while. He returns to his patrol car. He then returns back to the car that he's been searching, sometimes the exact same area he's been searching. Only this time, he tells the victim that he's found methamphetamine and paraphernalia in their car after he's gone back to his patrol car. And he tells them that he's going to do something called a field test kit. A field test kit, for those who don't know, you'll hear testimony that it's not the same thing as sending it off to a lab to be tested, but it's the best that we can do at the scene to tell if something is really suspected methamphetamine or not. And you'll get to see pictures of one in this case, and you'll see the defendant use them in some of these videos. But it's a little plastic sleeve, not very big, smaller than a credit card. And the idea is that inside that sleeve, a portion of the suspected methamphetamine or whatever it is put in there, usually with a Q-tip, and you'll see the defendant do it. And then some little capsules are broken up. And if it turns a certain color, that indicates that it's methamphetamine. The defendant tells them that he's going to perform this test, does the test, and when these change colors, he takes these people to jail. When this happens, these victims oftentimes will have these same reactions, Ms. Odom: complete shock and immediate, adamant denial. You'll hear some of them, like Ms. Odom, ask for some kind of testing. I mean, right there in the moment, you'll see it on the video. They'll ask for if there's any chance or possibility to get DNA testing on the item, fingerprints. Some of them even ask to provide a drug test right there roadside. Now, that's not what patrol deputies do, but you're going to hear that on the video. And just like Ms. Odom, the defendant he makes a choice to not document those things in his reports, but you will see them on the videos. You're going to hear that during the investigation of this case, the state and the Florida Department of Law Enforcement did that to the extent we could. And you're going to hear testimony in a few days about that and whether or not that was able to really show much. It's up to you to decide during this case what value to place on it. But you will hear that not one of those victims' fingerprints were found on those baggies. There's a number of factors that go into that, and they're going to testify to that. But that's what you're going to hear ultimately. Not one. You'll also hear that because of the way that these items were handled by the defendant on video, that these items were ripe for what's called cross-contamination. And an FDLE DNA analyst is going to testify, and they're going to tell you exactly what cross-contamination is and how it can affect what value testing may have on something. Specifically, she has watched the Odom video, and she is going to tell you what kinds of factors may or may not affect cross-contamination. As I said a moment ago, each one of these victims is going to tell you that they were in disbelief and that they were shocked. At this point, the defendant offers a potential alternative explanation. He asks each one of them the same thing. Has there been anybody else riding around with you lately who could have left these things in your car? Maybe it wasn't you. Is there anybody else you can think of? You'll hear him ask these people this on the videos. And the ones with no videos or a partial video, they're going to tell you, yeah, he asked me that. They're going to tell you that because they were panicked, they were in this emotional state, scared, they racked their brains trying to think of anybody. Who's been in my car? Who's been in my car? They'll tell you that. And they just said some of the first names they could think of, people that had been in their car. The victims, after things got settled, a few days later, some time passes, they're starting to think about this incident more. And they're going to tell you that those really weren't reasonable names that they put out. Yes, those people had been in their car, but they will tell you that either those people hadn't been in the car in days, they weren't in the car by themselves, they didn't see that person with drugs when they were in the car, they didn't know that person to be a drug, to have methamphetamine that day, or the defendant told these victims that it was somewhere in plain view, meaning it was like in a console, or it was on a floorboard right under them. It was in an area that they could see, and they know it wasn't there. They just know it wasn't there. Once again, like the Odom video, you're going to get to hear something directly from the defendant's mouth on one of these videos. And he says, after one particular victim is offered up one of these situations, somebody who's been in the car that maybe, possibly, I don't know, he says, it's just not common for a meth user to leave their stuff behind. So after asking them and prompting them, well, could it have been somebody else? He follows up with, well, it's just not common. Goes ahead and arrests that victim and takes them to jail. Then there are instances with victims where there's just no video at all. There's a few with a complete video, several with partials, and there's some with just none at all. And once again, those reports don't mention, the ones authored by the defendant, don't mention that his body camera wasn't working. He realized at a later date. They don't say that. You're going to get to see those reports. They will be items of evidence for no apparent explanation. In these instances, all we have is what the defendant, when he has complete access and control of their car, chooses to report later. Ultimately, all these victims, regardless of whether it's a complete, a partial, or no video at all, these victims will tell you the same thing. They will tell you that the defendant didn't find anything until after he had been back to his patrol car or went to the front of his car, to the side of his car, and got some gloves. Either way, he's back there. And then returns to their car. They will tell you that they all immediately denied it, said it wasn't theirs, and they will tell you that these drugs, this paraphernalia, was not in their car until after that man, Zach Wester, had been in their car. Now, you'll hear that once they were arrested, they were charged, they entered the court system, and you will hear that a portion of them did plead. They were charged for what he arrested them for. And a few of them did plea, and they're going to tell you about that as it becomes relevant, as they testify. And just like we said in jury selection, everybody in the room is slightly different, different motivations, different life experiences. They're going to tell you from right over there, the ones that did choose to plea, why they pled. Some are going to tell you that they had family, they needed to get home. Some are going to tell you that they just wanted this nightmare over with, and the plea deal didn't seem that bad to them, they could handle it. And then some are going to tell you that they believed it was their word against a sheriff's deputy, and no one would ever believe them over a sheriff's deputy. They felt powerless. Now, shortly after the last victim in this case was arrested, a lieutenant at the Jackson County Sheriff's Office named Mike Hodges began what's called an internal affairs investigation into the defendant's use of his body cameras. Internal affairs is a different part of the sheriff's office which exists to do just that, make investigations when they're needed into members of the Jackson County Sheriff's Office. Lieutenant Hodges, Mike Hodges, began that investigation in mid-July of 2018. And by August 1st, he made the recommendation that the defendant be suspended pending the outcome of the investigation. And he also made a recommendation that this matter be referred to the Florida Department of Law Enforcement for an independent criminal investigation. You'll hear that while that investigation with the Florida Department of Law Enforcement, you may hear that referred to as FDLE in this case. When you hear FDLE, that means Florida Department of Law Enforcement. While that investigation was still in its beginning, Lieutenant Hodges and another deputy had taken possession of Mr. Wester's badge, his gun, his patrol car while he was temporarily suspended. And you will hear that they kept that patrol car secure and they searched it in September of 2018. And that search is video recorded. You're going to get to see it from beginning to end. You'll see that they began their search at the trunk of the vehicle, an area that many times on video you'll see the defendant return to during these searches with these victims. They opened up the trunk. The front center is a duffel bag, like a first aid style duffel bag. It's pulled out by Lieutenant Hodges, and underneath it, stuffed in the back of that trunk, is a brown paper bag. It's actually an evidence bag, crumpled up, stuffed in the back. It's unlabeled. It doesn't have a case name or a case number on it. It's not secured, meaning it's not taped up as evidence you'll hear should be. There's no markers or identifiers on it at all to indicate what case this could be related to. What criminal case? You'll hear that there's also a policy of the Sheriff's Office regarding recovered property or abandoned property. If a deputy just finds something, the policy is specifically you're supposed to treat it as evidence. There's none of those markers on this bag. You'll see that bag opened up on video by Lieutenant Hodges. And inside the contents of that bag are a couple of boxes. One's like a little scope box, one's a little watch box. And inside there, you will see over 10 items of methamphetamine in baggies and in containers. You'll find 5 items of marijuana and pill bottles or residue in the bottom of that watch case. You'll see a syringe. You'll see a pipe. You'll see 2 plastic knives. You'll see rolling papers. You'll see over 30 small plastic baggies, empty, the same type, along with those 10 that had meth in them, same type that the defendant before this had claimed to have found on the victims in this case. Not one of these items was labeled or documented the way evidence is supposed to be in the way that the defendant was trained to handle evidence. The evidence will show in this case that's because it was not evidence from a real criminal case. Now, the search continued from the back of the patrol car and progressed to the front passenger side. In there, there's like a caddy station. A little kind of pull-over caddy that goes over the seat that holds things like your wallet, extra handcuffs, just extra things for convenience. And at this point, the video stops. The deputy that was assisting Lieutenant Hodges was taking a video with his phone, and he's going to testify, and he's going to tell you that he looked down, and all of a sudden he realized that it had stopped. He will tell you that he immediately tells Lieutenant Hodges that it stopped. They get it back up. They immediately state on the record, on the recording, what's happened and how much time has passed, and they make it clear that no search or anything has happened while they've been getting it straight, and then they continue. In other words, they document what happened and explain it. They continue into that caddy station, and in that caddy station, they found one of the defendant's black search gloves, the same kind you see him put on in the Odom video and in many of these other videos. Inside that glove, you will see what they find. They find a field test kit inside the glove. Again, not marked as evidence, no number on it. It's not inside an envelope labeled. It's a plastic sleeve, but it's not empty. It's got methamphetamine already in it. The capsules are not in there. It's not broken. It hasn't been activated or used yet. It's just preloaded in there, and you're going to get to see that. Next to it inside that glove is a clear canister. It looks like one of those old film canisters. And in that canister more methamphetamine. Unlabeled, unsecured, undocumented, not treated like legitimate evidence, like the defendant was trained and demonstrated that he knew how to handle and document evidence. And that's also because the evidence in this case will demonstrate that it wasn't real evidence. It was not evidence from something else. In fact, we will present evidence that the records of the Jackson County Sheriff's Office were searched to see if there was any record which existed to document the defendant seizing anything, making an arrest, performing a search with somebody else, finding some abandoned property and documenting it the way you're supposed to. No such record exists, and that's what you'll hear in this case. In sum, the evidence in this case will demonstrate that the defendant planted methamphetamine and paraphernalia in these victims' cars when he had complete access and complete control. He used this fabricated evidence to arrest them and take them to jail. He falsely documented these facts in reports that the sheriff's office relied on, the court system relies on. And once his patrol car was searched, it will be evident exactly how he committed these crimes. By keeping a supply of methamphetamine and paraphernalia in his patrol car and preloaded inside his search gloves for ready use to use against the citizens, the victims in this community. That's all, Judge.
Counsel.
Thank you, Your Honor. Morning, everyone. Yeah, my name is Ryan Davis, and I am here representing Mr. Zachary Wester. And you've heard from the state and what they believe the evidence is going to show, but remember, what the government says and what I say during our opening statements is not evidence. Just like back when we were at jury selection and the judge told you what the charges were going to be in this case, and he asked you if you had to vote right now, you'd have to vote not guilty because you haven't heard any evidence. And that's the same right now, today, as we're standing here. You haven't heard any evidence. You've only heard the opening statement of the state. But you, the jury in this case, you have the most important job, and that job is to decide what the facts are. And just because someone is going to get on that witness stand and swear to tell the truth doesn't mean they are going to tell the truth. It's your job to consider who and what is credible in this case. And you will receive some instructions at the end of the trial on judging a witness's credibility, but that doesn't mean you can't use your common sense. Everybody has common sense. And what you want to look for is you want to listen and watch the witnesses as they testify. Think about why are they testifying? What motives do they have? What, if anything, do they have to gain? And what interest do they have in how this case is going to be resolved? And as the prosecutor said, this case is essentially 12 drug possession cases. 12. But as the testimony is going on during this case, over this week and probably in the next week, there's some other numbers that I want you to remember. One of those numbers is 7. That's how many of those 12 entered into some type of agreement to resolve their case without challenging it in court. The other 5 were dropped before they could ever make it into a courtroom. 33. That's the number of felony convictions and crimes of dishonesty you're going to hear about from these 12 individuals, spread out amongst them. Now, not all of them will have a felony conviction, but we expect the evidence to show that there's going to be at least 33 prior felony convictions and crimes of dishonesty. 11. That's the number of backup officers that were on these scenes. That were right there. You'll see in these videos, from me to Mr. Wester right now, I could be a backup officer watching him search these cars in broad daylight. You'll see it on video. The number 11 again. How many civil lawsuits have been filed where 11 of these 12 are seeking money? Would that motivate their testimony? And finally, 0. Before Mr. Wester was suspended, that's the number of complaints against him about these cases. 0. I'm just going to go through briefly some of these individuals you're going to hear from. You're going to hear from a Joshua Emanuel. And in that case, you'll see the FHP trooper was also on scene, standing 15, 20 yards behind, broad daylight, watching the whole thing. You're going to hear from a Reginald Williams. Substance was found in his lunchbox. He also entered a plea. Steve Van, you're going to hear from him. And you also see that Dylan Jackson of the Jackson County Sheriff's Office was on scene. Mr. Van consented to his car being searched and does tell Deputy Wester, and you'll hear on the video, that after he finds the methamphetamine, he'll say, yes, I did. I had a girl in the car with me earlier named Crystal. And I don't know if that's a joke or what, but crystal meth? You're going to hear from Trevor Day. And you'll also hear from Jeff Tarter of the Jackson County Sheriff's Office on that case, who was there while that was taking place. You're going to hear from a Richard Driggers. And also about that stop, you're going to hear from Chris Maloney. At the time was with the Jackson County Sheriff's Office, now with the Florida Highway Patrol, who was there on scene while that search was taking place. You'll hear from Joshua Clenny. You also hear from David Carlberg, who was on scene with that case. And with the Joshua Clenny case, you're only going to see a video from the backup officer. And I'm sure this is one of the videos that the state was referring to, where they don't know where Mr. Wester's video went, or what happened to it, or why wasn't he following policy. But when that Joshua Clenny video plays, pay attention. Because at the end of the video, you're going to see Mr. Wester say, well, let me turn this off, and pushes the power button on his body camera. Now, it wasn't Mr. Wester's responsibility to keep track of those once he turns them back into the sheriff's office. That's Mike Hodges. And you'll hear about that as well. You're also going to hear from a Benjamin Bowling. And with Benjamin Bowling stop, you're going to have Billy Benton of the Jackson County Sheriff's Office on scene. And then Miss Teresa Odom. You're going to hear from her. And I believe the state has done a very good job of describing the video and how it looks. But you need to see it all for yourself. And you decide what's credible with that. And the state talked about Miss Odom asking for things to be tested. Right there. And the state was correct. That's not what the deputies do on the side of the road. They don't test for fingerprints. They don't, they're not testing for DNA. They don't have those capabilities. They do have the little field test kits that gives them a presumptive on the drugs. But again, that's not even enough for a conviction in these courts. It has to be sent to the lab, to FDLE, to their lab, for their analysts to take a look at it. And that's what you do when you litigate a case. You challenge the evidence. Ms. Odom says, he planted it on me. I want all this testing done. But she enters a plea, I think it's approximately 30 days later. You're going to hear from Maria Turner. Mr. Wester pulled her over for an expired tag. Said he smelled marijuana. And as what happens when deputies pull people over, yes, they do start racking their mind. Well, maybe somebody else was in the car. Maybe somebody did leave it. But I submit to you, it's going to be rare for somebody to get pulled over. Oh, you got me. It was mine. Take me away. Or is it more logical for people? I don't know what you're talking about. You're going to hear from Derek Benefield. And we believe the testimony from him is going to show that he was very adamant that he knew who was in and out of his car, and that the people that were in and out of his car would not leave something in there. Except for the night before Mr. Wester stopped him. Mr. Benefield was too drunk to drive his own car. Somebody drove him home, and he doesn't have any idea who it was. You're going to see and hear about the stop of James Fears. They were pulled over. The tag was not coming back, which would be a red flag for a deputy. And you also see that Trevor Lee and Rolf Smith of the Jackson County Sheriff's Office were also present on the scene. And that Trevor Lee, who at the time was with the Jackson County Sheriff's Office, but is now with the Bay County Sheriff's Office, participated in that search. And Trevor Lee was actually the one that found the drugs during that search. And then finally, Kimberly Hazelwood. You also see that Dylan Jackson of the Jackson County Sheriff's Office was on scene. And Deputy Jackson has a canine with him. The canine goes around that car and alerts that there's drugs in that car. And that's why Deputy Wester, at the time, searched the car. The dog said, I smell drugs in there. And Ms. Hazelwood will say, oh, I don't know anything about that. Somebody that I know that uses meth was in my car yesterday. And yeah, I purchased that container that it was bought in, but I didn't put it there. Now I want to hit a little bit on body cameras. You're going to hear more and more about the body cameras during this case. And we believe the testimony is going to show that it's about 2016 when the Jackson County Sheriff's Office first got body-worn cameras for their deputies. But not everybody got one. And eventually in 2017, pretty much by then, everybody else was going to have video cameras or body-worn cameras. And it was the responsibility of the deputies to make sure that they were docked. But there was also somebody at the sheriff's office who was supposed to be doing checks of the videos, making sure these videos are being downloaded, making sure that if there were issues that needed to be preserved, that they were being preserved. And that was Mike Hodges with the sheriff's office. And we believe the testimony and the evidence is going to show that he's going to have no records of anything he did, of any checks, any downloads, any maintenance, nothing. You might remember, well, yeah, I would check on them, make sure they were working, but he wasn't going back and reviewing and looking like he was supposed to. Because that was their policy, but that policy wasn't being followed. And you heard the state during their opening talk about policy. And they're going to say Mr. Wester wasn't following policy. So therefore, you shouldn't trust what happened with him. Well, it cuts both ways. Let's talk about the search of the patrol car that Mr. Wester was using. You heard the state say that they believe the evidence is going to show around July, mid-July, late July, early August is when they recommend FDLE take over the investigation of this case. And you're going to hear from the case agent, Ms. Chase. She went and she gathered up all kinds of evidence. All these reports, everything from, the sheriff's office, from the state attorney's office, gathering everything she could about all these cases, looking into everything. Why didn't she, or why didn't FDLE search his car? They had taken over the investigation at that point. That car sat there for 4 to 5 weeks before it was searched. And I believe the policy of the sheriff's office is going to show they have specific policies on how you store vehicles that are going to be used for evidence or searched for evidence. They have a specific area where that vehicle is supposed to be parked. That's not where his patrol car was parked. The keys are supposed to be put in an envelope, sealed, and put in the evidence locker. Well, you'll see on the video, Mike Hodges starts the video with the keys in his hand. First thing he does, hits the button, trunk comes open. But according to their policy, that should not have happened, because they should have had to take the tape off the trunk first, the evidence tape. Per their policy, doors, windows, trunks, taped to ensure that nobody accesses the vehicle. But it sat there in a place where it's not per policy to sit for 4 to 5 weeks. FDLE has already taken over the investigation, but yet Mike Hodges does the search. I want to talk a little bit more about different levels of proof when it relates to the law. The lowest level of proof that we have is what's called probable cause. Probable cause. Is it probable something happened? Did something maybe happen? As a patrol deputy, that's what you need to make an arrest or search a car. Probable cause. The next level we have is what's called a preponderance of the evidence. Tipping those scales that 1% in your favor, 51-49. You're at a store, you slip and fall because they've done something negligent, and you hire an attorney to sue them. You need to show by a preponderance of the evidence that they were at fault. Next level is clear and convincing evidence. Clear and convincing evidence. That'd be if there's a professional, let's say a doctor, who they feel is a harm. Maybe he's drinking before he's going into surgery or something. Well, they still have to prove by clear and convincing evidence that this doctor is a danger before they can revoke his license. And then finally, you have beyond a reasonable doubt. I have no reasonable doubt that this happened. And that's where we're at today. We're not at probable cause, like what Mr. Wester needed to pull these people over and search their vehicles. We're not at a preponderance. We're not at clear and convincing. We're beyond a reasonable doubt. That's what the state has to prove to you. But I also want you to remember, you're not here to just rubber stamp the government's case. You're here to test it, you're here to analyze it, and you're here to question it. Kind of a little example I thought of. Say you're getting ready to go take a road trip with your family. Maybe you're going to drive cross country, go see the Pacific Ocean. Well, most people probably before they took a long trip like that would take their car into a mechanic. Hey, you're going to take a long trip, can you check out my car? Well, you don't want the mechanic to go, looks good to me. No, you want the mechanic to get in there, check the tire pressures, check the oil, check the fluids, check the belts, look under the hood. What we don't want you to be is the mechanic that just glances over at this case. Don't just rubber stamp it. Inspect the case. Kick the tires of the case. Look under the hood. Again, you as the jury have the most important job, and that is to decide what the facts are and what really happened in this case. That's your job. And you'll do that by listening to the testimony, reviewing the evidence presented, and it's the state's burden to prove their case beyond a reasonable doubt. We want you to listen to how the state presents their case and the questions they ask their witnesses. They're trying to get responses from their witnesses that are going to aid their theory of what happened here. But also listen to the questions that are asked by the defense. And then you're going to weigh the credibility of that witness. Pay attention to their responses, their body language, their tone of voice. That's why our Constitution requires accusers to come in here and take this stand and not just submit written statements. Because you all have common sense. And we want you to use your common sense in judging the testimony from that witness stand. We want you to evaluate their testimony. We want you to look under that hood. We want you to kick those tires. And again, I've said this many times so far, but it's the government's job, the state's job, to prove their case to you beyond a reasonable doubt. We don't have to prove anything. We don't have to put anything on. But we do want you to hear from all the major players in this case. So that's why I can tell you right now, you will hear from Zachary Wester. He will talk to you about every single one of those stops and what he did. That's why we need you to wait until you hear all of the evidence before you start discussing it, before you start deciding. That's why the judge tells you, even on these breaks, you can't start talking before you hear it all. And I know that's hard, but our system of justice depends on you following those rules. But I submit to you that when you hear all of the testimony and you see all the evidence, you're going to find that the state has failed to meet their burden, and the state's going to give you no choice but to find Zachary Wester not guilty. Thank you.
All right, let's go ahead and do our first witness, and then we will take our mid-morning break. State, who would you like to call first?
Virgil Watson.
Virgil Watson. Mr. Clerk, I'm going to have you swear Mr. Watson in. If you'll keep him remain standing. Mr. State Attorney, do you want the podium moved?
Yes, sir.
You want
I
to
can
help
move
me?
it to
Thank you.
spot right here.
Yes, sir. Mr. Bellows going to help you with that.
Thank you, sir.
Good morning, Mr. Watson. Mr. Watson, will you raise your right hand for me, sir?
Do solemnly swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Watson. You can sit down. Mr. Watson, I want to talk to you really quickly before the state starts asking you questions. A couple things for me. Our jury is out here today, sir. So if you will make sure that, Mr. Watson, our jury's out here, sir.
Oh, okay.
Okay, yeah. So that's who you're speaking to today. Mr. Bailiff, if you'll raise your hand in the back for Mr. Watson. you got to speak loud enough to where he can hear you. That way the whole room can hear you, okay, sir? If you hear an objection, if you'll pause your testimony, let me hear what the objection is, and then I'll instruct you how to proceed, okay, sir?
Yes, sir.
All right, Mr. State Attorney?
Yes, sir. Thank you, Judge. Mr. Watson, same goes for me. I'll try to keep my voice up. If, with that divider there, if you can't hear me, just ask me to speak up, okay? All right, thank you, sir. Would you state your name for the record?
Virgil Watson.
All right, and are you employed anymore?
No, sir, I'm retired.
Congratulations. Before you retired, where did you work?
I worked at Jackson County Sheriff's Office.
All right, what was your rank or your title there?
When I retired, I was captain over investigations.
Okay. Now, you said you retired. Were you working there from 2016 to 2018, that period?
Yes, sir,
Okay. Do you know the defendant, Zachary Wester?
I do.
All right. Could you identify him here in the courtroom? Just say what color tie he's wearing and point to him, please.
Red tie.
Okay. Judge, I'd ask that the record reflect that Mr. Watson has identified the defendant as Mr. Wester.
The record will reflect this much.
Okay. Just, I'm not asking too much how, but just generally, how long have you known him? Did you know him, in other words, before 2016?
I've known of him, and I believe we actually met probably when his dad was running for sheriff.
That was going to be my follow-up question. Did you know his father?
I did.
Okay, and was his father also a member at that agency for a while?
He was for a while. Yes,
At the Jackson County Sheriff's Office?
yes, sir.
Okay, and was he a ranked staff? Specifically, was he beyond just a patrol deputy?
His father you talking about? Or?
Yes, sir.
Yes, sir. I believe he was the captain.
Okay, and was he in narcotics for a period of time?
He was.
In 2016, did the defendant come to work at the Jackson County Sheriff's Office?
He did.
Okay, and did he come from a prior law enforcement background?
Yes, sir. I believe he worked with Liberty County.
Okay. Now, when somebody is already a sheriff's deputy in another agency and comes to Jackson County, do they still have to go through some kind of training?
They do have of course, a field training program.
Yes, sir.
They have to go through. Now, if they're experienced, they will a lot of times go less than the full 16 weeks.
That was going to be my next question. So 16 weeks is with no experience, correct?
Right.
And then there's a lesser amount of time if they have prior experience,
Yes.
correct?
Yes, sir. It's up to basically the field training officer to determine, if he's up to par with our policies and everything.
Judge, may I approach the witness?
Yes, sir.
Mr. Watson, I'm going to show you what's marked as State's Exhibit 1A. You could open up that folder, just take a moment and look at it. Let me know if you recognize, yes or no, what's in there marked as 1A.
Yes, sir. That's Deputy Wester's ID.
Okay? And deputies that come and work with your agency have provided those kinds of IDs, correct?
That is correct.
Okay. Judge, at this time, I would move Exhibit 1A into evidence and move to publish.
Any objection?
No objection.
Be admitted.
Judge, may I approach the
Yes, sir.
course technology vendor? If you could just give me a thumbs up when that exhibit's up on the screen.
Need some help getting there? Let's see what you got. Give it 1 second, load up counsel. Thank you. Counsel, I think you got it up there.
All right. Thank you, Mr. Mayor. I was just going to ask you to zoom in. Now, there's a screen in front of you, Mr. Watson. First, I'll ask you, are you able to see that on the screen in front of you?
I am.
Okay, Judge, if we could, I see it on the screen for the jurors, but if we could inquire if it needs to be larger or smaller, just so that Mrs. Bittner, if she needs to zoom in or not.
You can zoom in as you need to, counsel.
Okay.
All right.
This is the front of that card, 1A, correct?
Yes.
Watson, okay. Mrs. Bittner, if you could zoom, just scroll down, so that we can see the back of Exhibit 1A. And we see that
Yes, sir.
oath there, correct? Could you read that into the record, Mr. Watson?
Yes. Says, I do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and of the state of Florida. That I am duly qualified to hold office under the Constitution of the state, and that I will well and faithfully perform the duties of Deputy Sheriff of Jackson County, on which I am now about to enter. So help me God. And it's signed Zachary.
Okay. Thank you, Mr. Watson. Now, you had mentioned the field training officer and the field training program, correct?
That's correct.
Okay, the records that a deputy completes documenting that they've completed that kind of training program, are those ordinarily kept and collected by the Jackson County Sheriff's Office?
Yes, they are.
Okay, may I approach the witness?
Yes, sir.
I'm going to show you what's marked as 1B, so field training. I'll take 1A back. And Mr. Watson, yeah, you could take that accordion folder. The lengthy document, but if you could just review the first couple of pages and yes or no, let me know if you recognize it first. You can take that rubber band off it if you need
Yeah.
to.
It appears to be Deputy Wester's FTO manual.
Okay, and he completed that training, correct?
Yes, sir.
And Judge, I would move at this time states 1B into evidence.
Is it B as in boy or D as in dog, counsel?
B as in boy.
B as in boy?
Yes, sir.
All right. Any objection?
No objection.
1B will be entered into evidence.
Now, I'll withhold publishing until a later witness, Judge.
Okay.
You had mentioned, Mr. Watson, policies and procedures of this agency, meaning the Jackson County Sheriff's Office, correct?
Yes, sir.
Okay. Was there a policy and procedure with the Jackson County Sheriff's Office at that time on the use of body-worn cameras or body cameras?
There was, yes.
Was there likewise a policy on evidence collection and processing?
Yes, sir.
All right, I'd like to show you what's marked as 1C and 1D as in dog. If I can approach the witness.
Yes,
Judge.
sir.
Record, I'm going to take 1D back and hand that to the clerk.
Got a mess here.
All right, first I'll hand you 1C. You could open that up and let me know if you recognize that to be that policy. Specifically, the policy on body-worn cameras.
Yes, sir. This is actually the Jackson County Sheriff's Office policy on body-worn cameras.
Okay, I'd move 1C into evidence, Judge.
Any objection?
No objection.
1C is admitted.
Again, I'll publish that to another witness, Judge. I'm going to show you 1D as in dog. Oh, I'm sorry, Mr. Watson, could I take that back? Show Mr. Davis that, sure. All right, I'm handing you 1D as in dog, and again, first, if you could look at that, let me know, Mr. Watson, if you recognize 1D to be the Jackson County Sheriff's Office policy on evidence collection.
That is correct. This is the Jackson County Sheriff's Office policy on evidence collection.
Okay, I'd move 1D as in dog into evidence, Judge.
Any objection?
No objection.
Be admitted as D.
May I reapproach the witness?
Yes, sir.
Mr. Watson, could you hand me 1D back? I want to keep all these together. Master accordion folder for 1A through D. All right, that's all I have at this time, Judge.
Okay. Mr. Davis?
I got just a moment, Your Honor.
Yes, sir. Take your time, sir.
We don't have any questions for this witness.
Thank you, sir. Mr. Williams, may this witness be excused?
Yes, but I ask that he remain under subpoena.
All right. Mr. Watson, you are not excused from all of your testimony in this case. There may be a chance you would have to be recalled for any reason. Thus, I'm going to ask you not to discuss anything that you talked about in here, any of your testimony in here, or any of the questions you were asked in here to any third party when you leave this courtroom. Do you understand? You, sir, you're still subject to the oversight of this court at this point.
Yes, sir.
All right. You are excused, subject to recall, Mr. Watson. All right. It's a good time for our morning break. It's 10:08. Let me talk to you, and I'm going to do a version of this every time, but the first time is critical that you understand what's about to happen. We talked at the jury selection about what scares a trial judge is not what happens a lot of times in the courtroom, it's what happens when you walk out the doors. And this is the first opportunity that you have to do that. I want to go ahead and remind you that you are not to talk with anyone, including your fellow jurors, about this case. Other than the bailiffs, everybody in the courthouse has been reminded to give you space. That's why you're wearing that name tag. That tells them to give you space. So if you see somebody in the hallway and they look like they're trying to avoid you, it could be because of COVID in this day and age, but it's probably also because you have that juror name badge on. So please don't take that as anybody trying to be offensive towards you. I've instructed them to give you space and to let you go about your affairs. Do not talk with each other about this case until the end of the case, and we're nowhere near the end of this case yet. So you can talk with each other, just not about the case. Don't look up anything. Don't do any research involving this case. Don't go turn your phone on and look at any news blogs about this case. Don't watch any television about this case. Don't call your uncle who is a lawyer and get their thoughts about this case. Do not do any research with respect to this case. Don't tweet, blog, or communicate with anybody about this case. What's going to happen is Mr. Gary is kind of your conduit between yourself and the court, and he's going to be your conduit for the next couple of weeks. It is 10:10 right now. He's going to lead you out of the courtroom. You are going to leave your notebooks in your chairs, and we will make sure they're secure over our break. He's going to lead you out of the courtroom, and you're going to be back in that jury room with Mr. Gary at 10:25. That's 15 minutes for a morning break, and we'll reconvene you with that court in that jury room at 10:25, and we will bring you back in. Mr. State Attorney, Mr. Williams, anything that you need from the court before we let them adjourn?
No, Judge.
Mr. Davis, anything from you before we let this jury adjourn for a morning recess?
No, Your Honor.
All right, we will be in recess until 10:25. Mr. Gary?
All rise.
Thank you, Mr. Gary. All right, we're going to come to West real quick. We'll let them begin to disperse as they need to. We made some extra bathroom facilities available to them, especially on a rainy day when there may be some limitations on going outside. Mr. State Attorney, anything that we need to address before the court takes its morning recess?
No, Judge.
Mr. Davis, anything from you before we take our morning recess?
No, Your Honor.
Counsel, if you'll be back seated at 10:20, it's about 10 minutes to take your morning recess. One thing I would ask before we get to the next witness, and I know the state's going to do this, is go ahead and take down what was published the last time, and we will continue onward. If the state will be sat and the defense will be sat at about 10:20, that will give us a couple minutes to talk about any preliminary matters before we get to our next witness, okay? All right, thank you. We are adjourned for our morning recess.
Yes, that's fine.
Good idea.
I'll tell you, apparently these mics are very sensitive. I had somebody already text me and say, we can hear you whispering, right? So, want to let you guys know too.
Walk through those doors just a simple
Stuff that goes in Mexico, back in Mexico, and it'll be right there.
Yeah.
That way you just grab it and you
Thank you. step behind you and use that trash can. Talk to you back.
Remain seated and come to order.
How we doing, Mr. Gary?
We are ready, Your Honor.
Okay, give me 1 second to get this back on here. Madam Court Porter, you good? Yes. Mr. Williams, who do you anticipate calling next?
William Chris.
Okay, let me pull my notes here. All right, we're going to go Chris next.
Yes, sir.
Okay. Is Arnold coming later today, you think?
He's the other witness in that room.
But we're going to do Chris next. Okay. All right, Mr. Davis, anything you want to talk about before we get going?
No, Your Honor.
All right. Let's look at this and we'll go. Everybody got water that needs water?
Yes, sir.
All right, Mr. Gary, if you'll bring them in.
All right. Leave your cell phone, personal items, record bottle, whatever you got ready.
All right, come to rest, please. All right, jury, that'll probably be our last recess through the morning break. Again, if you have, through lunch. If you have any hearing issues, again, please just raise your hand. I'm kind of looking out to make sure everybody can hear well, and we'll get started. Mr. State Attorney, you ready to call your next witness?
Yes, sir.
Who would you like to call, sir?
State calls William Crisp.
William Crisp. Mr. Clerk, you're going to swear him in again, okay, sir? Mr. Crisp, if you'll raise your right hand for me, sir.
Do you solemnly swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Morning, Mr. Crisp. A couple things before we get started. If you make sure you speak loud enough for Mr. Gary or bailiff in the back to hear you. Our jury is out here today, so we're speaking in that direction to where everybody in the room can hear you. The second thing is if you hear an objection, if you'll pause your testimony, let me hear what that objection is. I'll instruct you how to proceed, okay?
Yes, sir.
All right, Mr. State Attorney.
Thank you, Judge. Good morning, Mr. Crisp. Would you state your name for the record?
It's James William Crisp IV.
All right. And were you previously employed with the Jackson County Sheriff's Office?
Yes, sir.
For how long?
8 years.
Okay. And specifically, were you working with the Sheriff's Office in 2016?
Yes, sir.
All right. Do you know the defendant, Mr. Zachary Wester?
I do.
How so?
He was hired by the sheriff's office, and I was his FTO, or field training officer.
That was my next question. Could you say what an FTO is for the record? Okay. Field training officer. Had you ever been a field training officer before you were one for Mr. Wester?
Yes, sir.
All right. How much experience had you had being an FTO before Mr. Wester?
Several. I had done probably 4 or 5 new recruits through the program before Mr. Wester.
Would you just very generally tell the jury what it is that a field training officer does?
The
The program is designed for, it's a 16-week program designed to take someone that has just finished a basic recruit training program and passed a state board to be a law enforcement officer on the road as a deputy sheriff. Now, sometimes you get officers that come from other agencies that don't require a 16-week course to show that the way the Jackson County Sheriff's Office does business. They already know how to be a law enforcement officer, so they're just showing how the Jackson County Sheriff's Office does things. They still go through the book. They're still observed. All their calls are recorded. All their reports, anything they do like that is still recorded in the FTO manual, and it's still signed off on just like they went through the whole 16-week course.
Judge, this time I'd move to publish 1B as in boy, the field training manual.
You may go ahead and publish it, counsel.
Mrs. Bittner, if you could pull up 1B as in boy, specifically page 7 of that document. All right. Now, could I get you, Ms. Bittner, to scroll down? There's a bottom paragraph which begins with the FTO program will successfully culminate. Could you scroll to that? Okay, and Mrs. Bittner has her, the mouse there. We can't really highlight on this file, but are you able to see, Mr. Chris, where her mouse is?
Yes, sir.
Okay. Could you please read that paragraph beginning with that sentence, the FTO program will successfully?
Yes, sir. The FTO program will successfully culminate after a minimum of 16 weeks of training. Consideration may be given to shorten the training period to 3 phases for ROs, which is recruits, who show exceptional and above average performance. Can we keep going?
Yes, sir.
Consideration may also be given to shorten training periods to a minimum of 4 weeks for ROs who possess prior full-time patrol civilian law enforcement experience.
All right. Now, just to be clear, Mr. Wester, there's already been testimony that he had prior experience. Did he participate in the 16-week training or in the 4-week training?
It should have been the 4-week training.
All right, and you supervised him for that period, correct?
Yes, sir.
We're going to go into some specifics, but before we go into those, just generally, how did the defendant perform? Did he perform well, or did he struggle?
He performed exceptionally well.
Was he a trainee that, you mentioned that you had had other trainees, is he someone that you had to follow up on and remind things during that 4 weeks?
No, sir, not at all.
Did this training in the manual cover the use of body-worn cameras or body cameras?
Yes, sir, it did.
Okay, Mrs. Bittner, if I could get you to go to page 29 of 1B as in boy, the field training manual. We'll wait just a moment. All right. And on page 29, Mrs. Bittner, there's a top paragraph which begins with, "It is the policy of the sheriff's office." It should be at the very top of that page. Go up, right there. And if you could just, all right, Mr. Chris, do you see where her mouse is?
Yes, sir.
All right, could you read that paragraph into the record, please?
It is the policy of the sheriff's office that the VIVU, that's the brand name of the camera we were using at the time, cameras and/or in-car cameras are to be used on all traffic stops and pursuits. The camera is not to be used intermittently. It should run continuously from the beginning to the end of the stop or pursuit.
You mentioned that the VIVU cameras were the brand being used at that time, correct?
Yes, sir.
At a later date, did you switch to the Axon body camera system?
It was quite some time later. I believe we've had 3 different ones since the VIVU camera.
Did the policy remain the same, though?
As far as I'm aware, yes, sir.
Okay, and specifically what we've read in this paragraph?
Yes, sir.
That remained the same?
Yes, sir.
Was there also a separate policy apart from what's in here for the Jackson County Sheriff's Office regarding the use of body cameras.
Yes, sir.
All right, Mrs. Bittner, and Judge, I'd move to publish Exhibit 1C, the body camera policy at this time.
You can go ahead and publish.
Ms. Bittner, if you could pull up 1C on pages, let's start at page 2. Scroll down to section 2. Okay. Judge, if I could move around where I can see this better as well. Try to put my voice up. All right. Mr. Crisp, are you able to read on your screen the section that begins, I guess under 2.1, where it says BWCs allow for? Are you allowed to see? Are you
Yes, sir.
see that?
Yes, sir.
Could you read that in the record, please?
Yes, sir. BWCs allow for accurate documentation of deputy, public contacts, arrests, and critical incidents. They also serve to enhance the accuracy of deputy reports and testimony in court.
And just so we're clear, what are BWC?
That is body-worn camera.
All right, could you continue to read the paragraph number 2?
Yes, sir. Audio and video recordings also enhance this agency's ability to review probable cause for arrest, deputy and suspect interaction, and evidence for investigative and prosecutional purposes, and to provide additional information for deputy evaluation and training.
Okay, and then paragraph number 3 there. Could you read that to the record?
The BWC may also be useful in documenting crime scenes and other events that include the confiscation and documentation of evidence or contraband.
Bittner, could I get you to scroll down to page 6 of 1C? Page 6. All right, and there's a section number 2 on documentation. Are you able to see that at the top of the screen, Mr. Chris?
Yes, sir.
Would you please read all of 2, so paragraphs that are sublabeled A, B, and C under 2 documentation?
Yes, sir. 2 documentation. A is deputies shall document in charging affidavits and incident reports that a video was recorded from a body-worn camera and is evidence. B, deputies are permitted and encouraged to review the video recordings as a part of the thorough investigation when writing a report. C, if a deputy fails to activate a body-worn camera, let me start over. If a deputy fails to activate the body-worn camera, fails to record the entire contact, or interrupts the recording, the deputy shall document the reason in the incident report.
Mr. Crisp, did the defendant, Mr. Wester, demonstrate that he understood and knew how to follow these policies, whether it's on this separate policy on 1C or in the manual on B?
Yes, sir.
All right, and that's also documented, correct, in the manual, correct?
Yes, sir.
All right. Mrs. Bittner, if I could get you to go to 1B as in boy, page 87 of that document. All right, if you could scroll down towards the bottom half of that page, under a heading which reads Patrol Procedures, your mouse is there, correct? All right, Mr. Crisp, you're able to see where that is?
Yes, sir.
All right, and at the bottom of that section there, there's one that reads VIVU and in-car camera use. Is that correct?
Yes, sir.
All right, if you scroll across there to the right, it's got a date. What does that indicate?
5/19/2016.
What does that mean?
That is the date that we went over that policy together.
And it's got a recruit's signature there on that same date, correct?
Yes, sir.
And an FTO signature. Is that your signature?
Yes, sir.
Mr. Chris, did this training also, so moving away from body camera videos for the moment, did this training with the defendant also include how to collect and how to preserve evidence?
Yes, sir.
Mrs. Bittner, if you could go to page 193 of Exhibit 1B as in boy, the field training manual. All right. And if we could scroll to the middle of the page of 193, where it reads, have the recruit demonstrate. There we go. Scroll down a little bit further. All right, so now in the middle of the page, that paragraph, could you read that into the record, Mr. Chris?
Yes, sir. Have the recruit demonstrate how to properly secure, tape, label, and document evidence being submitted. This includes the documentation on both the package and the evidence or property sheet.
And did you do that with the defendant, Mr. Wester?
Yes, sir.
Did he demonstrate that he knew how to do it properly?
Yes, sir.
All right, I'd like to ask you about found and abandoned property. Was that covered in this training as well?
Yes, sir, it was.
All right, Mrs. Bittner, just one page, further, 194. The first paragraph of this, which begins with make the recruit familiar. Could you read that paragraph into the record, please?
Yes, sir. Make the recruit familiar with the department's policy regarding found or abandoned property. It is to be documented just as if it were evidence. It should be noted on the property receipt if a reporting person wishes to claim the property if it is unclaimed. Some designated property may be claimed by the finder after 90 days. Exceptions are weapons and narcotics, among others. Before the property is claimed by a finder, it must be advertised and a prescribed number of times in the local newspaper within the first 45 days that the department has possession of it. Property with the serial numbers removed cannot be claimed by a finder.
All right, and actually, let's read even one paragraph below that, beginning with when packaging and labeling. Could you read that into the record?
Yes, sir. When packaging and labeling property, the following information must be included: case number, name of defendant or subject if known, name of victim, offense, list of items included in the package, officer's name.
Scroll down a little bit, Mrs. Bittner. Just want to see. Okay. And then the sentence below that.
The above information should also be included on the evidence/property receipt.
Right. And the same question I asked you previously. Did the defendant demonstrate that he understood and was able to follow this aspect of your training with him?
I don't recall if we had a specific call with abandoned property, but this was gone over in the FTO.
Okay. And now when you say this, so maybe not for abandoned property, but for evidence.
The policy, yes, sir, for evidence.
Understood. Thank you. Was there also a separate policy apart from what's in this manual on evidence collection for Jackson County?
Yes, sir.
All right, Mrs. Bittner, if you could pull up 1D as in dog, the evidence collection policy. Could you go to page 4 of this document? Let's scroll down to sections capital B and C. If you could just bring those to the middle of the page, there we go. The first one labeled B, its header there is powder for narcotics. Mr. Chris, do you see that?
Yes, sir.
Could you read that into the record?
Powder from narcotics. All powder form of narcotics, i.e. cocaine, meth, will be put in either a glass/plastic collection vials or bottles, sealed, then placed in a plastic evidence bag. The vial or bottle will be marked in permanent marker with the case number and exhibit number. C, evidence marking. Items will be marked in such a manner that there is no damage or contamination to the evidence. The collecting member's initials should be placed directly on items of evidence for positive identification in later court proceedings. Items that cannot or should not be marked, such as hair, paint, stains, bullets, or items submitted for latent print processing, will be placed in a suitable container that will be sealed and marked.
All right, let's scroll down a little bit further, Mrs. Bittner. I'd like Mr. Chris to be able to see just, D for packaging.
D, packaging. Certain items of evidence require distinct packaging methods. The type of evidence seized will determine the factor for the packaging method utilized. Marijuana will be taken from the bag it was found in and placed in a paper bag, labeled and sealed. The bags that the marijuana was found in will be packaged in plastic evidence bags, labeled and sealed. These methods include.
Let's go ahead and read 1 first, which is for plastic bags.
Plastic bags. Plastic bags are suitable for small, dry objects not requiring serological analysis. Damp or biological items will not be placed in plastic bags. Plastic bags will be sealed with evidence tape and properly marked to prevent loss, contamination, or unauthorized access. The submitting officer must write his or her initials on both top and bottom of the evidence tape with black permanent markers, i.e. Sharpies. The label must be completely filled out with black permanent marker, no ink pens. Writing must be legible.
All right, and then Ms. Bittner, if you could scroll down to all paragraph 2 is, all right, and could you read paragraph 2, paper bags?
Paper bags. Paper bags are suitable for dry objects or for wrapping garments or large items. Paper bags can be sealed around the end or over. Paper bags can be sealed around the end or over area of large. That doesn't make any sense. Hang on. Paper bags can be sealed around the end or over area of large items such as tools, safes, and vehicle bumpers to prevent loss of adhering evidence. Evidence will be placed in the paper bag closed, top of the bag folded over, sealed at the opening with evidence tape and marked with the member's initials. The label must be filled out completely with permanent marker, no ink pens.
Scroll down, ma'am.
Thank you, Mr. Chris.
RS.
And likewise, did the defendant demonstrate that he understood and could follow this policy?
Yes, sir.
Ms. Bittner, if I could get you to go back to 1B as in boy, the field training manual, page 95. On page 95, in the middle of the list, and a header that reads evidence section. All right, I see your, there you go. Your mouse is moving around. Are you able to see where that mouse is?
Yes, sir.
Okay. If you just follow that evidence section across, it has a date. What date was that?
5/19/2016.
And there's initials out there to the side as well?
Yes, sir.
Okay, so are those yours?
Yes, sir.
Underneath that, what's the next header read?
Evidence rules and procedures,
And the date?
5/19/2016.
And those are your initials as well?
Yes, sir.
All right, and then right under that, the next header,
Evidence collections, processing, and preservation,
and the date, the handwritten date?
5/19/2016.
And are those the same initials?
Yes, sir.
Is this where you documented that you went over these areas with the defendant?
Yes, sir.
If he had not understood it or been unable to follow these, would you have signed this, initialed this?
No, sir.
Okay. Mrs. Bittner, could I get you to go to page 93 of 1B as in boy? All right, there should be a header which reads policy and procedure. And then underneath that header, collection and processing and preservation of evidence.
Yes, sir.
You see where her mouse is moving?
Yes, sir.
Okay. And how about that date?
It's 5/19/2016.
And are those your initials as well?
Yes, sir.
Does this also document where you reviewed this information with the defendant, and he demonstrated that he knew and understood it?
Yes, sir.
Mrs. Bittner, if I could get you to go to page 91 of 1B as in boy. Okay, there should be a header that reads evidence, collection, and procedure, third from the top. If you could scroll back up. All right, right there. Are you able to see? This page is a little bit darker, but are you able to see it?
Yes, sir, I can see it. Yes, sir.
And it specifically addresses the handout, and it's dated, correct?
Yes, sir.
And initialed by you as well?
Yes, sir.
Is this where the defendant demonstrated that he knew how to collect and preserve and submit evidence and follow these procedures?
This is the documentation where he was giving the information through the FTO manual and through the handout.
All right, moving on from evidence. Did this training also include, Mr. Chris, the importance of being thorough and investigating probable cause when arresting someone?
Yes, sir.
Mrs. Bittner, could I get you to go to page 21 of 1B as in boy? All right, in the middle of this page, there's a paragraph that begins the authority to deprive. Are you able to see that, Mr. Chris?
Yes, sir.
Could you read that into the record, please?
The authority to deprive someone of their freedom and permanently alter their future when you arrest them is one that should be taken very seriously. Some officers do not comprehend the weight of this responsibility and the consequence of their actions.
Right, and the next paragraph?
Never arrest someone because you are unable to determine who is at fault. Do not have the mindset that you will arrest them and let the court system figure it out. This is a lazy and irresponsible approach to the job.
Did the defendant demonstrate that he understood this information?
Yes, sir, he was given this information.
Mr. Crisp, did the defendant ultimately successfully complete this training?
Yes, sir.
All right, Mrs. Bittner, if I could get you to go to page 3 of 1B as in boy. All right, and do you recognize, go ahead and scroll down to the very bottom, Ms. Bittner, so we can see who wrote it, authored this. All right, do you recognize this, Mr. Crisp?
Yes, sir.
All right, and just generally, what is this? What are we looking at on page 3 of 1B?
This is a letter I wrote to Sergeant Shane Tipton, who was over the FTO program at that time. And it's a letter I wrote about Mr. Wester saying that he had completed the FTO program and was ready for solo patrol.
And specifically, it's not all that long, so I am going to ask you to read the body of that letter into the record.
Okay. Dear Sergeant Tipton, during the past few weeks, I've had the pleasure of being a field training officer for Deputy Sheriff Zach Wester. During these weeks, Wester has completed all the tests and training outlined in the Jackson County Sheriff's Office Field Training Manual. Wester, from the start, has required very little instruction. He is very knowledgeable in the responsibilities and duties of a law enforcement officer and Florida statutes. Wester conducts himself politely and professionally with everyone he comes in contact with. Wester's calls and reports show his dedication to his job and the citizens of this county. Wester has worked diligently to learn the policies and procedure of the Jackson County Sheriff's Office and has done so very quickly. At this time, I would like to recommend Deputy Sheriff Zach Wester for regular duty in the Patrol Division at the Jackson County Sheriff's Office. Sincerely, Corporal Will Crisp, Jackson 33.
That's all I have right now, Judge.
Cross?
Good morning.
Yes, sir.
My name is Ryan Davis. I just have a couple of questions for you. So you were Mr. Wester's field training officer?
Yes, sir.
And that took, you spent approximately 4 weeks with him?
Yes, sir.
And then obviously this was the end of it where you recommended him for the road?
Yes, sir.
Solo? Now, the prosecutor was asking you about some of the training and things you went through. I wanted to also ask you about on the, I guess it would be 1D, the Jackson County Sheriff's Office Policy on Evidence. You could pull it up for me. And scroll down to page 9. You can go down to the bottom of the page. Keep going, keep going.
You're on page 5, ma'am.
Yeah, you're on page 5. Go all the way down to the bottom of page 9 there. Vehicles or other motorized vehicles. You would have gone over this with Mr. Wester as well, correct?
Yes, sir.
And if we could if we could scroll down to section B, top of page 10 there. And then security. Could you read that paragraph for us?
Yes, sir. It's B, security, vehicles requiring processing to such an extent that an on-scene examination is not practical. The vehicle will be towed and placed in the evidence section, secured garage area, where the exposure to the elements is minimal.
I can stop you right there for just a second.
Yes, sir.
Where is the secured area of the evidence section?
At this time, it was a a garage next to the evidence section at the sheriff's office that could be locked up. It had a cage around it and a roll-up door, but it could be secured from the rest of the sheriff's office.
If you could continue reading that?
Let me see where I was. Okay. Evidence personnel will be notified when a vehicle needs to be placed in the secured area of the evidence so that they may open the doors. What that's saying is that roll-up door is going to be locked, so you needed to call somebody that had access to it to open the door.
Yeah.
The vehicle will have evidence tape placed on the doors and trunk. A vehicle impound envelope will be filled out and the keys placed in the envelope. The envelope will be given to evidence personnel or placed in the evidence locker. If needed, the FDLA crime lab will be notified to set up a time for them to process the vehicles or other motorized vehicles.
Okay. And so this policy came out in November of 2011?
I believe that's correct.
And this is a policy that was in effect when Mr. Wester became a deputy sheriff?
Yes, sir.
Okay. And this policy would have been known throughout the Jackson County Sheriff's Office, correct?
Yes, sir.
And that's your understanding is how, if you were going to secure a vehicle at the Jackson County Sheriff's Office, that's the way it's supposed to be done, correct?
If I'm securing a vehicle that needs processing,
Right.
that's the way it's going to be done. If I'm just towing a vehicle that was blocking traffic on the side of the road, it goes into a different section. This is for a vehicle that may contain evidence that needs processing either by our investigators or FDLE crime lab.
Right. And the purpose of that is to make sure that nobody can access the vehicle, correct?
Yes, sir.
So if a vehicle is sitting for 4 or 5 weeks, you want to make sure that it is secured and nobody is entering that vehicle, correct?
Well, I believe there's a policy on this, and the evidence collection and processing of that vehicle needs to take place within 3 days is what the...
Okay, so not only does it need to be taped up and secure, but it's also the policy of the Jackson County Sheriff's Office that vehicle needs to be searched within 3 days?
I believe that's correct. I would have to look that up.
Okay. If I can have just a moment, Your Honor?
Mm-hmm.
I don't have any further questions for this witness.
Thank you, sir.
Thank you, Mr. Crisp.
Thank you.
Mr. Williams, you have any follow-up?
I have some brief follow-up.
You can stay there, Mr. Chris. Thank you, sir.
Chris, just following up where Mr. Davis left off with you.
Yes, sir.
On page 9 and 10, what we've just reviewed here of 1D is in dog. That's referring to criminal investigations or criminal processing by the Jackson County Sheriff's Office, correct?
Yes, sir.
Okay. And I'll leave it at that. Thank you, Mr. Chris.
Thank you.
Mr. Williams, are you going to ask that Mr. Crisp be subject to any sort of recall?
Yes, sir.
All right, Mr. Crisp, your testimony for purposes of this morning is done. We may need you at a later date, so I'm going to ask that you not talk with anybody outside of this courtroom about the questions you were asked or the answers that you gave in this courtroom, okay? You are subject to recall under the umbrella of the court at this time, all right?
Yes, sir.
All right, thank you, sir. You're excused. All right, Mr. Williams, who would you like to call next?
Kevin Arnold.
Kevin Arnold. Mr. Arnold, if you'll raise your right hand, sir.
Do you solemnly swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. Thank you, Mr. Arnold. A couple things. If you'll speak to the back of the room, our jury's sitting out here today. We need everybody to be able to hear your testimony. The second thing is if you hear an objection, pause your testimony. I'll make a ruling on that objection and tell you how to proceed, okay?
Yes, sir.
Mr. Shade Attorney.
Good morning, sir. Would you state your name for the record?
Good morning. Kevin Arnold.
And how are you employed?
I'm a captain with the Jackson County Sheriff's Office.
How long have you been with that agency?
Well, over 25 years.
All right. Suffice it to say you were working there from 2016 to 2018?
Yes, sir.
Okay. In very general terms, would you just tell the jury what the patrol division is?
Okay. The patrol division is ladies and gentlemen that are dressed in myself in a uniform capacity. And we have the initial contact with most victims or citizens that contact us for service. We get calls for service that range from welfare checks to crimes that have been committed. So we go out and make contact with them and investigate those crimes. And do a lot of other functions. We serve warrants, civil process. They go to put on safety seminars and discuss some safety factors and different for the community. So we do a range of things in uniform patrol.
Yes, sir. Now, you mentioned that patrol deputies are in uniform, correct?
That is correct.
Are they also in marked cars?
In marked vehicles, yes, sir.
All right, that reads sheriff's deputy and kind of what we all consider police cars, correct?
That's correct. Now, we may have some supervisors that may be in some unmarked units, but they have a police package type unit.
Okay. I want to ask you, do you remember the defendant, Zachary Wester, coming to work at the Jackson County Sheriff's Office?
I do.
Was he assigned to the patrol division?
Yes, sir.
Now, I'd like to ask you what kind of information is available to a patrol deputy in his or her assigned patrol car? What access to information do they have generally?
As far as like a computer automated dispatch type system, it's a laptop system that's in patrol vehicles. And what the system has is our dispatch receives calls, telephone calls from the citizens or from different people, and it's put into the computer system and it's sent out, and the officers have access to see what the top calls that have come in that they're dispatched to. They also have access with certifications to NCIC, FCIC, which is a national database that can run criminal history, run tags, and that nature.
Okay. So if a patrol deputy has somebody's information, whether that's a license or whatever, they got it during a lawful stop, maybe they're giving somebody a ticket and they have their ID, would they, if they had that patrol car, would they have access potentially to that person's criminal history?
They could, yes.
Okay. You mentioned, I think you called it computer automated dispatch, is that correct?
Yes, CAD, that's correct.
All right, and that's what I was going to follow up with. Is that generally referred to as CAD?
Yes.
Or a CAD report?
It's considered CAD. A CAD report would probably be something you might pull out of the,
Okay.
IT might be able to pull out of the system itself.
Is dispatch a separate section from patrol?
It is. They're stationed at the sheriff's office.
All right. And generally, what is it that dispatch is doing as far as their interactions with patrol?
Dispatch, again, they can take calls for service. When citizens call, they want to report a burglary or theft or something in that nature, they'll contact dispatch. Dispatch will enter the top call that they're receiving with the information, with the victim's name, address, telephone number, and the details of the call will be put in. They work fire rescue, emergency type calls. They receive those through 911. Those are also put into a CAD system, and directed services for that type call will go out to fire rescue, could go to uniform patrol, would be first responders. So they take a lot of information that they gather and put into the system, and it can be directed back to the deputies on the road.
Okay. And if a patrol deputy is out on patrol during their shift and they have probable cause and make an arrest of somebody, they have the authority to do that, correct?
That's correct.
If they have probable cause, correct?
Probable cause.
All right. When that is done, does that same patrol deputy generally author the report documenting the incident?
That's correct.
And are those reports relied on by the sheriff's office to document that incident properly?
Right. The case that may be working, the incident report that's entered into the CAD system.
All right, just a moment, Mr. Arnold, Captain Arnold. That's all I have, Judge.
Mr. Davis?
No questions for this witness.
Mr. Williams, are you going to want Mr. Arnold to be subject to recall?
Yes, sir.
Mr. Arnold, if you'll do the court a favor, just in case you're needed to give further testimony in the case, if you'll not talk with anybody about the questions you were asked or your answers in this proceeding today, the state's requested that you could potentially be subject to recall. Okay, sir?
Yes, sir.
All right, you are released for the morning. Thank you, sir.
Thank you.
Who would the state like to call next?
Caleb Corbin.
Caleb Corbin. Mr. Corbin, will you raise your right hand for me, sir?
Do you solemnly swear or affirm that the evidence you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Corbin. You can sit down, sir. Mr. Corbin, that's the jury in the case. That's who you need to make sure you're speaking loud enough that all of those folks can hear you today. If you hear an objection, pause your testimony, and I will instruct you how to proceed. Okay, sir?
Yes, sir.
All right. Go ahead, counsel.
Good morning. Would you state your name for the record?
Caleb Corbin.
All right. And Mr. Corbin, were you previously employed by the Jackson County Sheriff's Office?
I was.
All right. Specifically, were you working there from 2016 to 2018?
I was.
What was your position? What part of the Sheriff's Office did you work with?
I was the network administrator for the sheriff's office.
You are a little bit soft-spoken. Would you mind repeating that and just speaking? And Judge, could maybe the jury indicate if they can hear him? I'm not trying to...
Everybody hear Mr. Corbin? If you can't, just raise your right hand and we'll make sure he speaks louder. But Mr. Corbin, Mr. Gary, raise your right hand, Mr. Gary. That's who you're speaking to. So when you talk, that's who I want you to talk to. You understand, Mr. Corbin?
Yes, sir.
Okay.
All right, could you just repeat what section of the Sheriff's Office you worked in and what you did for him?
Sure. I was the network administrator for the sheriff's office.
All right, what does that mean?
So basically, I was full-time IT guy. Any duties and roles, computer-related, body camera-related, stuff like that was my responsibility.
That's what I was going to ask, body camera related. Did your duties involve some interaction with the body camera system at the Sheriff's Office at that time?
Yes, it did.
All right. As such, were you familiar with how they operated?
I was.
All right. I'd like to ask you specifically about the Axon body cameras. Do you recall those being used at that time?
They were.
All right. And same thing, were you familiar with how they were operated?
I was.
Just generally, could you tell the jury, how they were designed to be positioned on the uniform, what they were designed to depict, that kind of thing?
So the process that we kind of determined with the body cameras is the deputy was allowed to put the body camera anywhere they wanted to put it on their chest area. We had some guys that wore it, right or left side of their chest. A lot of guys wore it in the center of their chest. Body camera was positioned there. Policy was developed and stated that anytime they got out on a call that they would turn on a camera. Actually, I'm sorry, it was at officer's discretion. There were certain calls that were depicted in the policy that they needed to be turned on for. But body camera had a switch on the top of it. You turned it on to start your shift, and then to actually start the recording with the body camera, you would double tap center of the chest and it would start the recording.
Let me ask you a follow-up there. You mentioned there were some that were distinguished, that there was officer discretion. What about a patrol stop where somebody is taken out of a car, a search is conducted, and somebody is potentially arrested?
Yes, it was definitely encouraged for them to wear that and have it on then, for sure,
Okay. Partially or from beginning to end? Or?
from beginning to end.
Okay. And you mentioned that there was a policy for that, correct?
Yes, sir.
All right. Let me ask you this. Would you describe to the jury the technical operation of the Axon body camera? So for instance, how could it even, you mentioned where it was positioned, but how could it be turned on?
So in order to turn the camera on, as I kind of touched on before, the camera had a switch on the very top of it. You just slid the switch. That would turn the camera on. That wasn't it recording. They kind of state it as a buffer state. It's recording, but it's not saving the video until the officer or deputy double clicks the center. There's a center round button in the center of the camera. They would double click that. That would jump the video back in time, about a minute in time, and that would grab both audio and video of the recording. Now, there was a lot of, if a deputy didn't turn the camera on with the slide switch, a lot of times they would get out, turn the camera on with the slide switch, and then press the record button in the center. So with that, it got, as soon as that, body camera was turned on.
And just to be clear, how would a deputy, was there a function of the camera to notify a deputy if it was actually on?
Sure. The body camera had three abilities to be able to let someone know, the deputy or someone around the deputy. It had an audible beep, it had a vibrate, and it had an LED on the top of it. The LED would blink green when it was on and red when it was recording. The deputy did have the ability to turn that off, and that would go into, can't remember the state of it.
That'd be called a stealth mode?
Yes, sir, stealth mode. They could turn certain features of the camera off, so they could turn off the LEDs, they could turn off the vibrate, they could turn off the audible beep. And that was it was at officer's discretion, more for officer safety. Don't want a big bright light on the center of their chest, or a beep letting someone know where they're at. But most of the time, the guys kept all that on.
Now, at the end of let's say a patrol deputy shift, what were they supposed to do with that body camera?
So at the end of their shift, if it was the end of a 2-day or 3-day shift, the guys worked a 2-day or a 3-day shift. At the end of their shift, they were to dock the camera at the sheriff's department and download all of the video that was on that camera.
Okay, that's what I was going to ask. How would a video that was captured end up getting preserved to where it could be used at a later date? So you said it would be docketed, correct?
It would be docked at there at the sheriff's office. We had 2 docks that were mandated. That was the only place they were to download their video. And then that was stored on evidencelibrary.com's Axon's cloud server that was stored off premise.
Okay. And were the body cameras assigned to specific deputies? So for instance, if I come in after it's been docked, am I going to get the same one back, or is it just up for grabs?
No, they were assigned to
Okay.
specific deputies, and we had actually labeled the back of the body cameras to say whose camera it was.
Okay. That's all I have.
Mr. Davis, pull that mic closer to him if you don't mind, Counsel.
Good morning, Mr. Corbin.
Good morning.
Yeah, my name's Ryan Davis. I introduced myself to you earlier.
Yes, sir.
Just a couple questions for you. So you were the IT person for the Jackson County Sheriff's Office, correct?
That is correct.
You were pretty much the office.
Yes, sir.
I understand that you work at the Bay County Sheriff's Office now?
Yes, sir, I do.
Same position?
I'm a network technician there. We quite a few more guys there, so a little bit less responsibility, but yes, sir.
Okay. And I'm assuming maybe a little better pay to move?
Yes, sir.
Now, the prosecutor's asking you about the Axon cameras. When did the Jackson County Sheriff's Office get those cameras?
I want to say it was probably around 2016, 2017. I'm not exactly for sure. There's documentation of exactly when we started using those.
Would the end of September 2017 sound familiar?
That sounds about right. I do know it was right before the end of a fiscal year. We went through a demo process of them. We used, had a couple that were used, and then we approved them, and then that's what we purchased.
And the cameras that you had before were a different brand, correct?
Yes, sir.
And those cameras, do you remember what company made those?
They were Provision body cameras.
Provision body cameras? Okay. And let's skip ahead again. So the Axon cameras, when the Sheriff's Office bought the Axon cameras, did you help develop the policy for those cameras?
With some guidance from both Axon and some other agencies around the state. Axon had provided several agencies around the state that were accredited agencies that were using the Axon cameras. They provided their policy. We kind of molded it to our sheriff's office, but yes.
Okay. And then, so the Provision cameras that were being used before, was there somebody at the sheriff's office that was in charge of checking and make sure that the deputies were using them properly?
There was,
Do you remember who that was?
that would have been Mike Hodges.
Okay. And with those Provision cameras, the policy at the time, how long were those videos kept for, stored at the sheriff's office?
They were stored for 90 days.
Okay. And if nobody went in and documented that, hey, these videos need to be kept, they'd be erased after 90 days, correct?
Not necessarily.
But they could be.
They could be, yes.
And Mike Hodges was the person that was in charge of making sure things were downloaded properly, correct?
That is correct.
And he would also be the one then that would delete videos that he thought were irrelevant.
Correct.
And then moving into the Axon cameras, my understanding was those are a little more secure in their system, correct?
Yes, sir.
And those cameras, when they're downloaded, the information is actually uploaded to a cloud.
That is correct.
And that's called evidence.com.
That is correct.
And there are certain administrators that have access to that to be able to delete videos at that point, correct?
That is correct, yes, sir.
And Mr. Wester would not have been able to delete his own videos that were uploaded, correct?
No, sir.
I believe you would have had that ability, correct?
Yes, sir.
And Mike Hodges?
Yes, sir.
Anybody else?
I believe there was a patrol secretary, and the only reason she had that access was for redaction capabilities.
Okay. And do you know how long the videos would be stored on evidence.com?
I believe we had it set for 120 days. State statute said 90 days, so we wanted to go ahead and extend it past that.
Okay, so you guys did another 30 days past
Yes,
what
sir.
the state statute required?
Yes, sir.
Okay. But there was somebody designated who was supposed to be reviewing the videos before they were deleted to make sure they have evidentiary value?
Yes, sir, that is correct.
Nothing further.
Any follow-up, Mr. Williams?
Just a moment, Judge. Could a patrol deputy also determine whether or not their body camera video had been actually loaded after it had been docked?
Could they log in to evidence.com and see their video?
Right. Was there a way for a patrol deputy to view to see, well, I made an arrest the other day, and I want to see if it got logged properly?
So initially, before the video was downloaded on the dock, the deputy could use their phone via Bluetooth to connect to the camera. it was just a monitor, a viewing device. It was not actually editing the video in any sort of way. They could actually watch the video, and then after the body camera was docked, then they would be able to log into evidence.com and actually see that video.
Mr. Davis asked you about your capabilities with your position. Did you ever delete any videos
No, sir.
related to this case?
No, sir.
Did you ever assist Lieutenant Hodges in deleting any videos from this case that pertain to this criminal case?
No, sir.
Okay, that's all.
Mr. Davis, any follow-up?
I can have just a moment. Nothing further.
Okay. Do you want to keep Mr. Corbin as a potential witness from the state's perspective?
Yes, sir.
Mr. Corbin, I'm going to ask you not talk with anybody outside of this courtroom about your testimony, the questions you were asked, et cetera. Today, you're still under the umbrella of the court through the remainder of evidence and testimony in this case. As the state has indicated, they may want to recall you, okay? Do you understand that, sir?
Yes, sir.
You are released for purposes this morning, okay? Thank you, sir. Mr. State Attorney, my thoughts right now, or maybe we can get one more in before lunch.
Yes, sir.
Who do you anticipate calling next?
Diana Chase.
All right. Diana Chase?
Judge, may Mr. Davis and I approach?
Yes, sir. Mr. Chase, will you raise your right hand?
Do you solemnly swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Ms. Chase, you may be seated. A couple things. Our jury is out where our audience normally is, so that's who you're speaking with. You need to speak loud enough so that everybody in the room can hear you. With these masks on, we're muffled at times, so it's important you speak up so everybody can hear you. Same thing is if you hear an objection, if you pause your testimony, I'll make a ruling on the objection and tell you how to proceed, okay?
Okay.
All right. Go ahead, Mr. State Attorney.
All right, good morning. Would you state your name for the record?
Diana Chase.
And how are you employed?
I'm a special agent with Florida Department of Law Enforcement.
Was your agency, FDLE, referred this case, this criminal case we're here for today, for an independent criminal investigation?
Yes.
All right. And were you assigned as the case agent for this case?
Yes.
Now, as such, did you collect case files for the listed victims from the Jackson County Sheriff's Office?
Yes, I did.
All right. And specifically, I'm going to ask you one by one about each one. Did you collect a case file related to Maria Turner from an arrest July 14th of 2017?
Yes.
Okay. And that case file, actually, let's keep going. Did it also include Mr. Reginald Williams
Yes.
from an arrest of August 30th of 2017?
Yes.
Mr. Benjamin Bowling from October 2nd of 2017?
Yes.
Mr. Derek Benefield from October 16th, 2017?
Yes.
Mr. Richard Driggers from February 9th, 2018?
Yes.
Mrs. Teresa Odom, February 15th of 2018?
Yes.
Mr. Joshua Clenny, from March 14th of 2018.
Yes.
Mr. Joshua Emanuel from April 8th, 2018.
Yes.
Mr. Stephen Van, April 17th of 2018.
Yes.
Mr. Trevor Day from May 4th of 2018.
Yes.
Mr. James Fears from June 3rd, 2018.
Yes.
And Mrs. Kimberly Hazelwood from June 7th of 2018.
Yes.
And have you reviewed state's exhibits, composite exhibits 2 through 13 before today?
Yes.
Okay? And just for the record, there are 2 boxes here in the courtroom. Are they contained in these 2 boxes?
Yes.
Okay? Do those include the case files that you previously testified to?
Yes.
And do those case files include things like the arrest reports from those incidents,
Yes.
the offense reports,
Yes.
any seized items that the defendant allegedly seized from those listed victims,
Yes.
the FDLE chemistry lab reports indicating what kind of drugs they may have tested for or not,
Yes.
any potential chain of custody records for those items showing where they went and to whom.
Yes.
Do they also contain booking information or what may be called a jail detention report showing somebody was booked into jail and for how long?
Yes.
Do they also include discs of body cameras which relate to those arrests made by the defendant for those victims?
Yes.
Now, not every one of these contains a body camera video, correct?
Correct.
Specifically, which ones do not?
The ones that do not contain a body camera are from Maria Turner, Reginald Williams, Benjamin Bowling, and Derek Benefield.
Okay. Judge, at this time, I would move state's exhibits, composite exhibits 2 through 13 into evidence.
Any objection?
No objection.
2 through 13 will be admitted.
Judge, at this time, I would move to publish only 2A, an arrest affidavit and complaint related to Joshua Emanuel. That's 2A.
Be published.
Just a moment, Ms. Chase, getting the technology connected. There it is. Are you able to see that on the screen in front of you?
Yes. Yes.
All right, if it's all right, I'll try to keep my voice up, and I'll step around here where I can see it as well. All right, is this generally what we would refer to it as an arrest report?
Yes.
If you could, Agent Chase, and I'll guide you, but if you could describe the relevant portions of this arrest report related to Joshua Emanuel to the jury. In other words, orient them to where relevant information is found. So for instance, how do we know who authored this arrest report? Who wrote it?
If you look at the top box, it lists the agency name, so that would be the agency, and then the arresting officer and investigating officer, which are both the same in this case. That would be the author, and you can also see that on one of the next page as well.
Okay. So just to be clear, in the sections, a box labeled arresting officer and investigating officer, who's listed there?
Yes, Zach Wester.
Okay. And then there's also a 4-digit number behind it. What is that?
That is, that was Zach Wester's Jackson County Sheriff's Office identification number at the time that this report was written.
And in the top left-hand corner, in a box labeled agency name, would you read that to the record, please?
Jackson County Sheriff's Office.
Okay. And then we have a, Ms. Bitter, could you zoom in maybe just one click? Okay. We have, it looks like it's box number 8 labeled defendant's name. Could you read that name into the record, please?
Yes, it's Emmanuel Joshua Alec. Joshua Alec Emmanuel.
Okay. And is that where it's indicated who, not necessarily the defendant in this case, but who's being arrested?
Yes.
All right. And let's scroll down a little bit, Mrs. Bittner. All right, right there. Under boxes 25, 27, and 29. What generally is included in those areas of the arrest report?
So this is the charge description. This is what the person arrested was charged with in this case, which is, they're listed here, and then with the corresponding statute number.
Ms. Bittner, could you scroll down a little bit more, please? All right, now in this bottom right section, number 59, are you able to see that?
59, yes. Well, it's a signature, and then the complainant signature, and then name typed out.
Okay. And right where it says 59, would you read into the record those words, or do we need to zoom those in a little bit?
Now I can see, I certify that all the above information is true and correct to the best of my knowledge, and is page 1 of a 3-page affidavit/complaint.
All right, so Mrs. Bittner, let's scroll to the second page. Now here in this box, it's number 84, narrative of the factual basis. Do you see that?
Yes.
All right, and then inside the box, just so we're very clear, what type of information is included there?
This is the officer's narrative as to what they are saying occurred in this incident.
Okay. We scroll down a little bit, Mrs. Bittner. All right. And once again, in the left-hand side, marked 85 is a signature box, correct?
Yes.
Right. And could you read the language right next to the number 55 as well?
85.
Yes.
The undersigned, being duly sworn, states that the foregoing information contained in the affidavit consisting of 3 pages is true and correct to the best of his/her knowledge.
And in the box immediately to the right of that, labeled 86, could you read that as well?
Sworn and subscribed before me this 8th day of April 2018.
Now, Agent Chase, all of these reports that are contained in State's Exhibits 2 through 13, these are all Jackson County Sheriff's Office reports, correct?
Yes.
And do they all depict sworn statements by the defendant
Yes.
of incidents alleged to have occurred within Jackson County?
Yes.
That's all, Judge.
Okay. Mr. Davis?
Morning.
Good morning.
Ryan Davis. You go Agent Chase
That's good.
or Special Agent?
Agent Chase is fine.
Just want to make sure I get it properly. When was FDLE assigned to take over the investigation of Mr. Wester?
It was in August of 2018.
Okay. Was it August 1st?
I believe so. That was when a complaint was received.
Okay. And your job, as part of your investigation, as you told the state, or in answering his questions, you went and gathered up all these different case files, correct?
Correct.
And that includes the reports like the one we're seeing there, the videos, which we'll see some later, all those types of things, correct?
Correct.
And the videos, where did you get the videos from?
The videos they were a combination. I got either from the Jackson County Sheriff's Office themselves or from the State Attorney's Office.
Okay. Which ones did you get from the Jackson County Sheriff's Office and which ones did you get from the State Attorney's Office as it relates to the 12 case files that you have here?
Okay, let me try and remember.
Do you have something that would help refresh your memory? Would you need to take a look at the box?
That might help.
We could let the witness step down, Judge, so she can
Let's
take a
do
look.
this. Let's just bring the box over here to her right, if you don't mind. Her left, I'm sorry. Put them on the floor, and she can take a second and peruse those in the court's presence.
Not that heavy.
Thank you, Mr. Davis. Take your time, Ms. Chase.
Okay, I'm going to try and go through.
Okay.
In
And
order.
take your time, because we just want to make sure we get it correct.
Okay, so to the best of my memory, so like I said earlier, bowling did not have a video associated with it.
Correct.
Teresa Odom, I received from the state attorney's office.
Okay.
Maria Turner did not have a video associated, and neither did Derek Benefield. James Christopher Fears was received from the state attorney's office. Kimberly Hazelwood, I believe initially came from the sheriff's office, but I might have also received it when I asked for it from the state attorney's office as well. But initially, it came from the sheriff's office.
Okay.
Joshua Emanuel, I'm not sure, I believe that came from the state attorney's office as well. Reginald Williams, like I explained earlier, did not have a video associated with it. Steve Van, I believe, was one of the cases where I received it from both the sheriff's office and the state attorney's office, as was Trevor Day. Richard Driggers came from the state attorney's office, and so did Joshua Clooney's.
And the cases that don't have the videos, Turner, Bowling, Benefield, and Williams, did those all take place in 2017? Were those arrests by Mr. Wester in 2017?
Yes.
Okay. As also part of your investigation, you did not search Mr. Wester's patrol vehicle, did you?
I did not.
Okay. Did you ever try to get a search warrant for his vehicle?
I did not apply for a search warrant.
Okay. Did anybody from FDLE apply for a search warrant for his vehicle?
No.
Okay. Were you ever asked by the sheriff's department to come search his vehicle?
No.
Stop. Sidebar. Ask the question again, counsel.
Yes, sir. Did anybody from the Jackson County Sheriff's Office ever ask you to search Mr. Wester's vehicle?
No.
Okay. Nothing further at this time.
All right. Mr. Williams, anything else?
No, Judge.
All right, and I think Ms. Chase may be back to see us for some later testimony.
Yes, sir.
Ms. Chase, you are still subject to the oversight of this court. You're not released from your overall duty to testify, so do not talk with any other witnesses or third parties about what testimony you've given today or about what questions you were asked in court, okay, ma'am?
Yes, sir.
All right, thank you, ma'am. You're released for the morning, though. Thank you. All right, Mr. State Attorney, you agree this is a good point for a lunch recess?
Yes, sir.
All right, jury, this is going to be the point we break for lunch for the morning. We've got some things we need to get taken care of for this afternoon for you to get ready to go. Again, I'm going to kind of go over everything just to make sure we're all on the same page. You are not to speak with each other about this case at all. Let me repeat that. You are not to speak with each other about this case at all. at this time. We're not even close to the time where you can speak with each other about this case. So just assume you can't do it until I tell you otherwise. You are not to look up anything. You are not to research anything having to do with this case. You are not to talk with anybody, either in person, by phone, by any electronic device, about what you've heard or seen today, or your thoughts or anything about this case. If somebody approaches you about this case, I instruct you to flee, was the word we used last Wednesday. Get away from them and report it to the bailiff immediately. You are going to be allowed to go off-site for lunch today or off-campus for lunch, so you've got some flexibility there. Just make sure you preserve the integrity of what we're doing here today, and I know I've instructed you on numerous occasions now on how you're going to do that. It is 11:45 right now. I'm going to ask that you be back seated in that jury room at 12:55. Again, that would be an hour and 10 minutes for your lunch recess today. That's a little extended. We may not go that long every day, but I think where we're at is appropriate for that amount of lunch recess. Again, Mr. Gary is going to assist in escorting you out. You're going to leave your notepads in your chairs. We'll make sure those are preserved in a safe place over lunch. You are also going to leave your name tags on, and we will see you back in that jury room at 12:55. Is there any reason they shouldn't be excused, State?
No, Judge.
Defense? I'll be back in that jury room at 12:55.
All rise.